Hi, chat. Apparently Clyde doesn't want to look at you anymore, but got his haircut. All right, buddy. Want to put you down? There we go. Anyways, hello, everybody. Welcome. It is Thursday. Hello. Sorry about that being a couple minutes late. Yes, he is a cute doggo. We try to do our best for him. Let's see. Yes, the Clyde smell test. Oh, he smells great right now. Game Paddler says, "Raid square per Nick." There's not much square up on. I mean, he ain't getting shit right. That's it. That's it. Torgo the White. Yes, we're gonna get to that. Yes, for $2. Did you see the machine gun ban ruling in Kansas? Yes. We are gonna get to that. It's very interesting. It's a very interesting ruling. Very interesting case. And then Brooks, saying, "How was last night?" Oh, last night. Ooh. Yeah. It was a long night, chat. Long night burning the coffee there. Anyways, guys, if you guys are new, hello. Welcome to the Thursday night show. My name's Sean, also known as Potentially Criminal. I am a practicing attorney in the Cleveland, Ohio area. Focus on criminal defense, but do a little bit of everything. And tonight, we're going to be covering a couple different topics tonight. Some of the obvious ones. Obviously, Nick Rekieta had his Omnibus yesterday, and kind of what I thought was going to happen. It was going to be kind of uneventful, given the timing of the motions he filed. Cain Velasquez, you guys remember, he's facing charges of attempting to murder a couple people. Well, Cain tapped out. And then we've got Takia Young. If you guys remember her, she is a woman who was killed by police during a attempt to stop her. About this time last year in Ohio, and her attorneys, the officer who shot her has been charged with murder. So, that's where we are with that. And hold on here. Just want to say hello to everybody. We got people everywhere, including Rumble, Twitch, and obviously here, last but not least, on YouTube. And then can't forget people on Locals. If you guys are new, Locals is at potentiallycriminal.locals.com. It's everything that you wanted Patreon to be, and you thought Patreon would be, but it turned out Patreon couldn't do to save their life. That's the best way to describe it. Anyways, over at potentiallycriminal.locals.com, you get access to the community for free. It costs you nothing to sign up, and you get to hang out with us. You can post things there. We can respond to things. I can respond to things. You can respond to each other. It's a very fun time there. If you wish to support me, it is only $3 a month. You pay for 2 months. You pay for 10 months, you get 2 months free. Not the other way around. That would not be very profitable. Anyways, with that support, you get access to everything. You get access to the 2 live shows a week, which I think are truly the best bargain in town. Normally, we do have them every once in a while when things drop. For example, with Nick's dropping his suppression motion that apparently isn't a suppression motion, even though it says suppression in the title. It's really about Frank Street, Delaware, which, okay. According to Nick. We cover those. And then also every Thursday night after this show, we have a live show. We get to hang out. All the stuff we can't talk about here, all the stuff that's not appropriate for YouTube. And then just things we might run out of time for. That's over at potentiallycriminal.locals.com. If you want 1 month free access, you use the promo code BoogerSugar, and you get free access to everything. So let's see here. Why is it still up? So is it tax-free? No, it is not tax-free. I'm sorry, it's not tax-free. I wish it was. Which Frank's was listed once and never cited, really. Yeah, I know that. Remember, I brought that up. There's like I said, this is, if that was the, we'll get to it in a minute, chat. We're going to get to all of it in a minute. If that was, I would never do that. And I turned in a 5-page brief today for a case regarding some First Amendment issues. And mean, shit. How many? It's only 5 pages long, and how many cases did I cite in this? I cite. I mean, like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Yeah, I mean, shit. Like 13 of those, 6 statutes. And it's all organized. You use Roman numerals, you use letters, break down your organization to readable chunks. Just organization is your friend. Organization is your friend. I just don't understand why it's such a big deal we couldn't do it right. Whatever. I am not here to argue with that. That is someone else's decision to do that. So we are. Hold on here. Why did this thing not show up? All right. So we've got a couple different things to get to. Now we've got 7 minutes in. We're trying to get. You know what? We're going to get started now. We are going to get started, guys. We got 406 people here. 469. Let's get started. Couple of super chats. We'll get these out of the way real quick. Richard Gruber, like I said, well, I always love the AK drum in there. Love that. It's a timeless picture. Saying, is a Frank's Challenge a court-sanctioned hot dog eating competition? If so, can I have Joey Chestnut pinch in for me? Yes, sorry. Doesn't work that way. Sleazy says, I hear a cuck is still hunting the rage piggy. Depends which. I don't know who you're talking about. That could go multiple ways. And Stop Moss B says for $10, I'm not saying Nick is using Ralph to dox and leak information on his blood enemies like Nick Fuentes was using Ralph for. Yeah, I know. I'm not saying. I'm just saying. We'll see, though. We'll see. We'll see how bad the rage twig is going to flail after all this. Brain says, do I do divorces? Here and there. Not very often. Not very often. Where are we at here? Who was a special guest at the DNC? I don't know. Actually, hold on. This is a good question. Who was a special guest at the DNC? DNC's guest speaker. Who was it? They claimed it was going to be. Do we know yet? The special guest was Pipkin Pippa. Oh, yeah. Well, Elizabeth Warren was there. I'm sure they were thrilled to have the fake Indian lady there. Okay. Oh, well. It was Nick. Trent says, good on you for not doing divorces. Divorce lawyers are a certain type of scummy. I mean, here's the thing. You could say that, but I mean, they're guys doing their job and they're good at their job. No, I don't treat them. I don't look down upon them. Dealing with guys, murdering, robbing, and possessing child pornography. Like, I'm not robing myself in honor over here. A lot of, people like to give divorce attorneys bad raps, but mostly it's the people getting divorced that cause the issues more than anything in my experience. So that's just how I see it. Oh, it's Alec Baldwin. Conspicuous design says, his name is John Cena. Yes, that's who showed up. All right, anyways, let's get going. What do we have first? We had Nick Rekieta's Melancholy Omnibus. So what happened? Well, the Omnibus hearing is where you go and challenge everything. Motions to dismiss, motions in limine, motions to suppress. Whatever it is you're going to bring, you got to bring there. You do it all at once. And then you get ready to move on if the case moves on from there. We learned on Monday, guys. I know we covered the motion. Nick filed it's funny because it happened at an omnibus, but Nick filed a omnibus motion of his own, basically alleging multiple different things, and he served it on the prosecution 2 days before the hearing, which really doesn't give them any time to prepare. Doesn't really give them any time to respond or do anything really necessary. So it's not really that helpful. So the prosecution asked for more time, and the court granted it because, of course, they're going to need time to respond. They are going to need to know what's going on. And yeah, I mean, there were a couple issues. Apparently, the prosecution agreed that April, if she testified, she'd have to testify for any of her statements to be used against Nick, which wasn't really, okay, cool. Now, and it's the issues remaining where we'll just cover these very quickly because I know a lot of you have already seen it, but I know some of you haven't. And I want to make sure you guys know what is being alleged. So we're just going to get to this very, 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 very quickly. And this is like the 10,000 foot view. Now, despite what Nick says, it is a motion for multiple things given, just by reading the title. Again, that's how we simple folk here in Ohio do it. It's a motion to avoid the warrant. It's a motion to suppress evidence and dismiss charges for lack of probable cause. So you're doing a bunch of things all at once, which isn't a problem here. Basically, he's trying to kill it. Simple enough. We all know what it is. Now, they point out the warrant was supported by probable cause, and the main way that they're claiming probable cause was not supported is through what happened with the statements made by the police. And they're claiming under the court case of Franks v. Delaware, which, it's very funny because it's very similarly worded the way Nick wrote his thing, which is kind of weird. But he says he didn't do it, but I don't know. Anyway, Nick is arguing that the police lied and made intentionally false statements or were reckless in their statements, and those are material statements. Therefore, the court should punish that by throwing out the warrant. Now, one of the things they go after is the issues regarding Aaron. They claim that, we'll get to the first part here. The first issue is that the detective said he was able to review the video that was taken off Nick's YouTube and Rumble social media sites. Now, obviously, it becomes down to how do you read the sentence? Was it taken off of there like he went on there to get him, which Nick says is impossible because he privated the data, which I don't know why you would do that, Nick. I mean, that's telling the police you have relevant evidence is never usually a good strategy. Or was it that he was able to view videos that people had taken off of Nick's site and made downloaded? Well, that's the more likely answer because he was able to go ahead and figure out a lot of different things. They say the videos are 524 and it talks about Nick, having his big cope session. So they get going here and they point out that one of the other issues that they didn't really hammer on this a lot in the hearing, apparently, were the letters from the children's services people who said that 2 days prior, Alicia Sweep sent a letter saying the May 16th report does not fit the definition of child abuse or neglect as we have defined. So all she was saying is, look, we don't have any grounds to go look. Remember, the police can use the information on their own, so they did. They didn't really focus on this one, and it's surprising they kind of let that sit. The other thing is they claim that the police lied about Nick and Aaron having a falling out, when in reality, they were at each other's throats, it sounds like. So that was a misstatement. That was a lie. And it's like, I don't know. I think it's clear they don't fucking like each other. And Nick's argument is, because of that, Aaron is biased. He can't be trusted. His information is not credible, except it was corroborated by other parties and including Nick himself. So strike, like womp womp. And then, yes, this becomes the issue of Nick, or they're looking at Nick's videos. And they're pointing out that they didn't go to Alphabet or YouTube to get a warrant to view the videos. And that if they viewed any clips, those clips are not valid. Well, because they have watermarks on them. Because there's watermarks, that means they're edited. Yeah, I don't think this is going to go the way Nick thinks it's going to go. Trying to, they lied. I don't. And as he went on his little rant last night, well, I know because I did this case years ago. And I know when I read the case, you got BTFO'd on your Frank's argument. The judge said, nope, they didn't lie. And if they didn't lie then, this is far less sketchy conduct than then, Nick. So don't think you're going to win there, home slice. Don't think you're going to win. You should reread your case. Anyway, they want to argue that pursuant to Frank's, the court must find the search warrant devoid of reliability and void. Not happening. Really not happening. A firearm search was unlawful. I mean, they found guns where the drugs were. They're allowed to take those. I think they're going to have a very tough time trying to make the arguments there. But and the final issue was, and it's funny because it took them forever to do it. And once again, chat, when you are writing, don't do widows and orphans. Clean your shit up. Get this onto the next page. This is just, ugh, that's just sad. Now, there are confrontation clause issues with April making statements to the detective because Nick has the right to confront her. So, yes, she's going to have to come in and testify if they want to bring any of it up. So there we go. That's Nick's stuff that's Nick's in a nutshell. Not really impressive. You know, I would have been embarrassed to write this myself. So we're not going to do that. We're not going to talk about that. That's it. Yes. Nick, hide the Baldo. The cops are here. So yeah, that's it. Jill Sturgis says, "Wait, YouTube is public. No warrant needed." No, but you would need to contact Alphabet to get a hold of that stuff. Now, if they really wanted to be a dick, they could go to Nick and say, "Here's a warrant for your cell phone. We want that. We want to access YouTube and remake the video public so we could take it." I mean, you've acknowledged you have access to critical evidence and you have it on your phone. Never a smart idea. Never a smart idea. But once again, that's just me being an attorney. Mike says, "Can police use a Wayback Machine to pull videos?" They can, but you're going to have to explain why you can't get to the real one. Yes, and also last night, guys, there was a public records drop. The final part of the Rekieta children custody hearing, and Nick got BTFO'd by the judge twice. And despite what Nick said, and we covered it last night, and that's the reason why I didn't cover it again today. If you guys want me to cover it, not when it's like 2:30 in the morning and I'm partially falling asleep, we can relook at it, chat. I just didn't feel that's fair to you to do it and then try to like almost redo the thing again. But if you guys out there want me to rewatch it, we can do it. We can do it. But yes, Nick got BTFO'd, and I will say this much. Nick's attorney and Kayla's attorney, the court appointed attorneys they had, did a phenomenal job. They did very, very good at what was going on. They tried to get Nick and Kayla immunity to turn over their follicle samples, like the amazing, elusive hair follicle samples we've never heard of and seen yet. They tried to get immunity for that. They did a lot of good goddamn things. And the biggest problem for Nick and Kayla is they weren't able to cooperate. And it's not that they refused to. I get that they can't because they're worried about the criminal case, but their attorneys worked with what they had and did a pretty damn good job. They made a very, very good argument. It's just at the end of the day, you're not going to be able, like, you're bullshitting the court, and the court knows it, so they're not going to let you send the kids home. So, yes, the malpractice factory lawyers, yes. Which, once again, Nick, if you think they were malpractice factories, you'd better go report them, or you're a pussy. If they're that dangerous and they're that bad, fucking report them, or shut the fuck up. Don't come out here and fucking tell me they're bad and then you don't do anything about it. If they're bad, stop the bad man. Look like I give good hugs. Yes, I do. Cain Velasquez says, if I saw you on the street and asked if you're Sean, would you forsake the name your daddy gave you? No. No. No, I'd be like, oh, shit. I'm like, hope you don't want to hug. So Joe says rewatch. Okay, I'll put up a poll later and we'll take a look at it. Yes, it's myopic reading. Oh, let's see here. Oh, T. says, if Sean loves hugs, if you see him, hug him. No. Please don't. I'll give you a handshake. Don't be a gunt and run away. No. I would rather you give me a handshake. Please give me a handshake. Please don't try to hug me. Please don't. Scarecrow says, I'm not sure what set Nick off, but he's going all in on Pomplin lying to obtain the warrant, even in Dale Twitter threads. Yeah, well, guys, remember, he knows something we don't know. You know, he knows something we don't know. That's James says, what's up, bucko? I'm literally driving right now. Just wanted to peek in and say hi. Lol. Well, thank you for being here. Drive safely. Drive safely. Scarecrow says, following at the last minute shenanigans also increase the likelihood April goes rogue and Nick's playing hot potato with that grenade. Yeah, but remember, guys, at the end of the day, a lot of attorneys file stuff at the last minute. You take all the time you can get. I just know in Nick's situation, they've had 2 months to get ready, and then this is the best they did. I'm a little disappointed. 2 months to prepare. And then arson investigator for $49.99 says, check out Nevada versus Robert Tellis. The defendant took, yes, he is a former politician in Clark County, Nevada, who is accused of murdering a newspaper reporter who had discovered this politician was being a scumbag. So he murdered the newspaper reporter, and now he's trying to explain why it's not so weird. His DNA was all over the crime scene, and why the dead guy's DNA was in his house. It's very, very funny. We'll take a look at that. We might look at that over the weekend because he took the stand, and I watched about 5 minutes of his testimony today. Holy shit, it is hilarious. It is very hilarious. Whiskey says, if you see Sean, hug him. Got it. Please don't. Scarecrow says, Nick's narrative on stream is the omission of the CPS letter, misrepresented Aaron's animus, and using Cog's clip. And if they did, the judge denied them. Yeah, but like I said, I don't think it's going to go well for Nick, but we'll see. There's always a chance, but very likely he's going to get felted. And then Kat Williams gifted five subs. Thank you, Kat. All right. So, yes, guys, that is the big thing there with Nick. I'm sure there'll be more coming. MN Public Records, come on. I hope you've got more in there. More in the tank, but we'll see. We shall see. Okay. And then where is... Let me see here. So we are going to move on to Takia Young. You guys don't remember her. She was, I'm going to bring up the video here. This is, why is this not working here? So we're going to bring up the video. I know YouTube's probably going to nuke me here, but we're going to do the best we can on this because it just went down. YouTube just moved it. There's a Takia Young. I don't know how you say her name. But anyways, Takia Young, she was in a body cam situation. And, well, here we go. Here's the... Here is what happened. So, guys, when we started covering this story, these cops were helping get a car door open. And somebody from the nearby grocery store said, hey, stop this lady. She stole a bunch of booze. And from there, the cops will move on.
I take the 29, 3705 Managua, 3705.
And some of you guys are wondering, wow, these cops seem very nice. They're popping open a door. Yes, this is like the McWhitersville area of Columbus, Ohio. So these are like the nice cops.
Male hallucinating. Much of a for 10.
Oh, show the screen. Oh, shoot. Sorry. Okay. I thought I did here. Oh, all right. Sorry. I thought I did. I clicked over. Oh, well. Here we go.
Attention 29, 3705 Onagwa, 3705. A female is hallucinating. Much of a for 10.
Out of the car.
So as you can see, they're trying to get her out of the car, and he does what? He's walking around to the front.
Service 1828.
Get out of the car. Then get out. No, then get out. Get out of the car. Get out of the car. Get out of the car.
Okay, and from there, yes, Doxyland over in Rumble says hello, hi. So you can see from right there, he gets in front of the car. Why? Why did he have to get in front of the car? Did she drive into him? Well, I mean, he got in the way. I mean, I would argue at some point you don't get to create your exigency. And that's what I would argue. It's an exigent situation. It's an emergency. You don't get to do that and then run around and say, oh my gosh, I was in fear of my life. And we're going to skip to the other side. We'll skip to past it. And here you go. So this is after he shot. This is after he shot her and she's dead.
Shots fired.
And
Stop.
I love the fact they shot her. She's like all slumped over the seat. And they're like, stop driving. And it's like, dude, come on. You know she's dead.
We're going to have a 34 on.
So.
She's going to be at.
And see, hold on, chat. 1 second. Laney thought 2.0 was home. But I think it's great, YouTube. See, I missed the gunfire, so you can't get mad at me now. So here's the second officer.
Attention 29, 3705 Onagwa, 3705.
What's that?
Female is hallucinating. Much of a for 10.
Hey, stop. Hey, out of the car. 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 They said your stole stuff, do not leave. Get out of the car. Then get out. No, then get out. Get out of the car. Get out of the car.
Oops, we missed that. We didn't catch that in time. So, did it turn out she had stolen things? Yes, she had. She had shoplifted from Kroger. And yes, here's just another view from that side. The officer 2 in slow motion. And see, there you go. And just, that's where she shoplifted from Kroger, so they shoplifted her life. Oh my gosh. That's the... Oh my gosh, you guys. You guys are something else. You guys are something else there. So anyway, here's the rest of it. as he's going. And yet there they go, chasers. Go Speed Racer. Go Speed Racer. Go Speed Racer, go. All right. The challenge for today is Sean to pronounce her name correctly. I tried. Steve H says she shoplifted and used her car as a weapon. Yes. But I do think there's a bit of an issue when the police insert themselves in front of the car and then go, oh my gosh, she tried to run me over. It's like, yes, she's probably going to try to get away. If you were really worried about that, you could have taken like your car and, blocked her car. So she goes, boop. And then nobody gets hurt and you don't have to shoot at anybody. I think it was entirely nonsense they did it that way. He could have gotten on the way. She wasn't even moving that fast either. Well, yes, there's that too. Yes, the wages of sin. Sure, she found out stealing liquor was not the best idea in the world, but that's a separate issue. Should she have done it? No, she shouldn't have. But hey, there's a reason why they probably warned her, quit fucking around. You'll get what's coming to you. And she didn't want to, so she got what was coming to her in that regard. I don't feel too bad about her, but I do not appreciate the police conduct. So you can feel that way for both of them. The world did a good job. I got a 2-for-1 special. So that is and I've been trying to find a copy of the indictment, guys, and I have not found it yet. And I'm a little frustrated because it's not around. But he's been charged with multiple counts of murder and multiple counts of manslaughter. So we will find out 4 counts of murder, 4 counts of felonious assault, and 2 counts of involuntary manslaughter. Which means at some point, with the murder charges, he's looking at a minimum of 15 years to life in prison. That doesn't mean he will do just 15 years. He'll do a minimum of 15. There's a potential he could face up to life in prison on those. He's not being charged with aggravated murder nor a death penalty offense. The counts of felonious assault, he looks at like 2 to 8 years in prison. And the involuntary manslaughter is very likely 3 to 11 years of prison. But as you can tell, the bigger issue for him at this point is going to be the issue of the life in prison issue here. So as of right now, he has not had a lot done on his case. There hasn't really been any hearings. The reading of his indictment got waived. He was just in court last week. Let me see if I can find something here. I may as well let you guys see what I'm looking at here. Oh, because I found it now. Finally, I found it. They uploaded it. 8/13, his indictment was filed. No, that's bull. Let's see. He's already, they filed for discovery, and his reading of the indictment was waived. He entered a plea of not guilty, which, makes sense. That's what you should do. He already went ahead and entered a plea of not guilty. So he is not guilty. He waived the reading of indictment, waived straight up a court. He waived any defects of time, place, and manner of service. And yeah, he is going to be all set there. Now, I think that, this one is kind of like the pot lady. Someone asked it down here below. I feel like he shouldn't have stood in front of the car. I agree. Yes, 0% recidivism. Yes, it's very true. It's the best recidivism in the world. Hold on here. Someone just texted me. What do they want? Okay. Driving away isn't a weapon. No. Nate Matthews says, you wouldn't shoplift a bullet. Oof. Oof. Yes. Yes, you cannot create a deadly force situation. They teach you that. Yes, and like I said, guys, the biggest thing is the exigency involved in this. Ports of Thunder says, what did she steal? She stole some bottles of alcohol. That's it. Some liquor. She stole liquor, which it's weird. She's like was fairly pregnant and she's stealing alcohol. Like, what are you? Oh, hold on 1 second. Hi, sweetheart. 2.0's home. Hold on, guys. All right. Yeah, she stole alcohol, which is a very stupid thing. Is that the dog or my stomach? No, that's the dog. When she goes like, she's got a weird bark. She's got a weird bark. Dude says, I'm going to let you go for a handshake and then I'll pull away and say, too slow, Sean. Well, thank you. Walter Malone says, Jesus took the wheel there. Yes, it did. Charlie says she's ghost riding that whip. Yeah, she is. Whiskey Sour says, hi, Sean. I've been waiting over 18 months for a background check to clear concerning an NFA item. Is it a machine gun? Because I'm surprised. 18 months is a long time right now. The 4-4s, especially the e-filed ones, are like, boop, 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 boop. They're like zipping right out the door. So I'm surprised you're hung in there. You might want to try to reach out to the ATF and see what the deal is. That's a very long time now, especially in this day and age. JC Adult says, what about a foot in the door? Oh, I agree. I think that's bullshit when they do a foot in the door. Because now they're entering the home. They're obstructing me from closing if they've entered my home illegally. And do I think this is as egregious as the incident out of Illinois with the lady with the pot of water? No. I mean, that guy's a fucking lunatic, and he deserves every bit of prison. Do I think this guy should get murder? No, I could see it being manslaughter, but the guy in Illinois should definitely be getting murder. Bob says most cannons are not NFA items. That's correct. Most black powder cannons are not. But a lot of things are. And then Whiskey Sour for $49.99. It says, I'm just wondering if I can do anything because the ATF sent my background to the FBI. Sorry, message got cut off. I'm just wondering if legally I can do anything about it because the ATF sent my background. The FBI, sorry, message cut off. I understand what you're trying to say there. Thank you for the super chat. You know, you can contact them and say like, hey, what's the deal? Do you need anything else from me? I don't know what your holdup is. That 18 months, especially nowadays, is really long. The only thing I could see is, are you doing it the trust route? Are you going through a trust or an LLC or some sort of cover organization? And then, yeah, are you doing it for a machine gun or something like really huge? Other than that, I can't imagine why it's 18 months right now. But 18 months is, I mean, heck, I think it's been within 18 months I did the, and it's been over a year since I did, I think it's been close to a year since I did that guy. Or actually since I SBR'd the braced thing, and that was like a 30-day turnaround, so yeah, it might be. I mean, but yeah, it all depends on what you're doing. Test Channel now says, oh, that lady in Illinois, boiling water is a deadly weapon. Yes, but when you tell that woman, go grab that deadly weapon and come over to me, and then she says something, I rebuke you in the name of Jesus, you don't get to act like a scared little bunny and go, I don't know what that means. Because that's what happened. I rebuke you in the name of Jesus. And he goes, I don't understand what that means. Put your gun down. Ah! It's like, that's what he did. And he just panicked. And he shot the lady. So, no. He should be in trouble for what he did. Unforced Ego is saying, for $20, seems like if you followed your NFA form before whatever change they made, it'll still take forever. It's only new submissions are happening fast. One of mine went through in 1 day. The other in 2 weeks. Both filed this year. Wow. 1 day. That's amazing. That's nice. That's nice. I just want to suppress my staccato. Well, that sucks. And that's all you're waiting on. It's nothing like that's pretty basic. 1 day though, you'll get it in your staccato. We'll just go pew 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 pew. It'll be fun. It'll be a lot of fun. Bella is saying, how did that jerk cop not know I rebuke you is a common saying? Because he's a piece of shit. That's why. He was a career, he'd only been doing it for a while and had been through 6 departments, got drummed out of the army, had a couple of DUIs, wasn't exactly shooting for the stars at that point. Nima says an NFA trust. Yes, you can do a trust for National Firearms Act items. Prior to 2017, that was a way you could do it where you weren't required to submit fingerprints and pictures of the people in the trust who would have access to the weapons. It was actually a very quick way to do it, and it was a very low-key way of avoiding all the paperwork from the feds. 2017 rolls around, they remove that, so anybody who's running the trust has to submit their paperwork, fingerprints, and pictures to the ATF now. The neat advantage of using a trust is multiple people can possess the item at once. You could do a trust or an LLC. A trust is better, though, because a trust you don't ever have to re-update or keep filing on. You create the trust, it exists. The other good advantage is with a trust, you can kick people out of it and get rid of them. So, for example, if you own the NFA item on your own and you get slapped with a protection order, you get slapped with a red flag order, you're going to have to find somebody who can take care of that item for you. So, you're going to have to go find an FFL or an SOT that can take care of it and, diagnose it for malfunctions or something. Or you can be in a trust and you are hereby kicked out of the trust. You no longer have access to the gun. The other thing is should you die, you can pass those items along, and then there's no need for a Form 5 at that point because you're just written out of the trust. The trust keeps operating and nothing's there. So it works. It works. It's got its advantages. Not as many as it used to have. Not as many as it used to have. Let me see here. What are you looking at there? Yeah, what a playboy. What's up, Alpha Fox? Good to see you, man. It's been a little while. It's been a little while. Yes. And as I said, Cyber Rat, yeah, everybody on the trust who's running the trust has to submit their information. Whereas if you're doing it by yourself, it's just you and it's easy. Blade 2.0 says, sounds like what you're trying to do is we need to abolish the ATF. Yes. And yes, I agree. It's meant to slow down the process, but also they want to restrict the amount of people with NFA items. Unlike a lot of things out there, like the EPA is about protecting the environment. The ATF is not about protecting firearms and firearms users. So it's a very different thing there. And Nima is a new member. Thank you. Thank you very, very much. Thank you. So we have some interesting news, guys, that came out of the District of Kansas today, and I do think this is worth looking into. We're gonna get to this now. This is pretty cool stuff. And this is a case of somebody who, well, it turned out to be a win for the good guys. And the federal government has been, the federal government got BTFO'd, and there's nothing wrong with that. So this got filed yesterday, and this is filed in the District of Kansas. Not Arkansas, just Kansas. And Tamori Morgan was the defendant. And he had a motion to dismiss based on Second Amendment grounds. Well, what was his charge? Well, he was charged under, and they said he finds the government failed to establish a nascent history gun regulation justifies the application of 18 U.S.C. 922-0 to the defendant. 18 U.S.C. 922-0. For those of you who may not know, and here, we'll bring it up, 18 U.S.C. 922-0. Well, that's a very, very fun part of the... All right, chat, so here we go. This is 18 U.S.C. 922, Title 18 in the United States Code, Section 922. Section 900 and onwards deals with firearms. Well, here we go. Unlawful acts involving firearms. Well, let's go to it. Section 922-0 says, except as otherwise provided in paragraph 2, it shall be unlawful for any person to transfer or possess a machine gun. Now, there are exceptions if you are a governmental agency, okay, or you had a lawful transfer that was before the date this took effect. So basically, your machine gun cannot be privately owned if it was made after May 19th, 1986. Well, yes. Yes, this is the Hughes Amendment. Oh, so this guy got charged with possessing a machine gun. And yes, fuck the Hughes Amendment, yes. Anyway, he had charged with 922-0. And the court's granting his motion to dismiss. So he was charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. 922-0. Specifically, he's charged with possessing an Anderson Manufacturing Model AM-15, basically an AR-15 and 300 blackout, and a machine gun conversion device. It was established at the hearing the device is a so-called Glock switch, which allows a Glock Model 33 and 357 SIG to fire as an automatic weapon. There we go, chat. We finally got a switchy case. It's time to break it out.
Switchy. No talk. No cap. No talk.
So if you guys don't know what switchies are, they are little things you put on the back plate of a Glock pistol, and you go flick, flick, and you go with it as you want. And they are literally, you can buy them off the internet for pennies at this point, almost. So he had a fully automatic AR-15 and he had a full auto Glock. A true Renaissance gentleman. That guy went hard. That guy's gone harder in the paint than we have for the Second Amendment. Yes, the Glock 18 gang rise up. Yes, very true. Yes. Yes, and somebody said in there, Mike's 420 Adventure, shit. But yes, homie had him. So this is interesting. The right of the Second Amendment. Under the Second Amendment, the right of the people to keep and bear arms shall not be infringed. And they cite the Second Amendment in Heller, and it extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And to keep arms simply means to possess arms. And they say if the plain text of the Second Amendment applies to a defendant's conduct, the government has a burden to show the regulation is inconsistent with this nation's historical firearm regulation tradition. And we learned that from Clarence Thomas's greatest masterpiece, Bruen. The standard requires a historical analog between the modern regulation and historical regulations, not a historical twin. And that came from Rahimi. So you have to find something close. You don't have to find the exact thing. Now, he claims that the 922-0 counts are unconstitutionally facial as applied to him. So there's two ways you can challenge the constitutionality of a law: as it's facially applied, and as applied. So you're challenging the fact that it's unconstitutional no matter what on its face, and then you're challenging it, saying as applying it to me, it's unconstitutional. So he argues that under Bruen, the plain text applies to the possession of machine guns. The government argues to the contrary, pointing to language in Heller that suggests the unconstitutionality of machine gun regulation would be startling, and that the Second Amendment only applies to weapons that were commonly used by law-abiding citizens at the time of the Second Amendment's enactment. Now, this is the 10th Circuit, and they say they have yet to apply Bruen to 922.0. Therefore, the court starts its analysis at the beginning, and this is the problem. There is no advice for him to look to. Kansas in the 10th Circuit, so he can't look up and say, what does the appellate court say? Or what does the Supreme Court say? There's nothing there yet. He says since 922 makes it unlawful to possess a machine gun, 922 incorporates the definition of a machine gun from 26 U.S.C. 5845, which is that right there, chat, is the National Firearms Act. That is the citation for it. If you want to go look for it, look it up. It's interesting because it's in the tax code, because the NFA originally was just a tax on things. And it defines what a machine gun is. Now, machine gun is any weapon which shoots, is designed to shoot, or can be rarely restored to shoot automatically more than one shot without manually reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively, or a combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in the possession or under the control of a person. Now, they say the court notes that definition is broad. It does not, for instance, include a projectile in the definition like the definitions for a rifle or shotgun do. Nor does it require that a projectile or shot be expelled through the energy of an explosive or propellant, as contemplated on the definitions of rifle or shotgun or any other weapon, or destructive device, which any other weapons and destructive devices are other regulated items. So they say, thus the definition seems to encompass everything from aircraft-mounted automatic cannons to a small handheld taser gun or stun gun that can easily be placed inside a handbag, which shoots multi-shot bursts of electrical particles with a single pull of the trigger, or a fully automatic BB gun that shoots multiple rounds of metal projectiles using compressed air. And he says, this court is not faced with a situation where the government has charged someone with the illegal possession of a taser or a BB gun. But the example of the aircraft-mounted gun seems fatal to defendant's facial challenge. The plaintiff fails to show how an example like this would constitute a bearable arm within the Second Amendment's protection. And to succeed on a facial challenge, and this is where, he's got him mixed up here. I think that was just a mix-up by the judge, and that happens. The defendant must show that 922 is unconstitutional in all its applications. The court thus proceeds to the defendant's as-applied challenge. And then he says, here the defendant is charged with 2 counts of machine gun possession, and both counts apply to arms that can be carried in the hand. Thus, by definition, the machine gun and the Glock switch are bearable arms. The government relies on Heller to argue that machine guns are not covered by the plain text. The Heller language cited by the government is unavailing. Interesting. He says, first, the government's interpretation of Heller relies exclusively on dicta. Yes, Antonin Scalia's dicta. And circuit authority that predates the historical analysis mandated in Bruen. Machine guns were not at issue in Heller. That's very true. Second, the government's interpretation would run directly counter to the essential analysis in Heller. Just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. And that's true, because yes, that's the argument you hear people making all the time. Well, that means the First Amendment only covers a pen and a pencil. It only covers the printing press. The Fourth Amendment doesn't cover cell phones or cars or really any other things, just your home and your person. Well, that would be retarded. No, not my dicta. Dicta. Dicta meaning it is not part of the opinion. It is a judge kind of musing. Third, the government relies on the comments in Heller regarding United States v. Miller. Yes, Miller, the case in 1939, for the longest time, the only case that had dealt with the NFA that had ever gone to the Supreme Court. Miller was already dead. And of all the Supreme Court justices, only one of them they decided a shotgun didn't have military necessity. Only one of them had served in World War I, and he was a JAG officer, meaning he served as a lawyer in the rear. So a bunch of judges saying that a sawed-off shotgun had no use in war, and they missed the biggest war of that time to that point. So the Supreme Court rejected in Miller a challenge to the National Firearms Act prohibition against carrying an unregistered sawed-off shotgun across state lines. Interesting, over half of the opinion of Miller was devoted to explaining how, in the years preceding and immediately following the enactment of the Second Amendment, one of the lawful purposes for which law-abiding citizens possess modern firearms was for service in the militia. The court surveyed several laws from that era that not only permitted but essentially required law-abiding citizens to provide for their own military-style small arms. Against that backdrop, the court concluded the sawed-off shotgun was not the type of weapon that'd be useful for military service. In Heller, the Supreme Court simply observed that Miller fit within the tradition of regulating dangerous and unusual weapons. Moreover, it bears noting that unlike um, 922, the National Firearms Act does not categorically prohibit the possession of sawed-off shotguns at issue in Miller or the firearms at issue in this case. Rather, that act regulates the possession of such weapons by restricting possession to those who comply with the registration and taxation requirements imposed under the act. And he says, Heller, because it predates Bruen, however, certainly does not say the Second Amendment does not apply to bearable machine guns. It merely implies that restrictions on dangerous and unusual weapons can be consistent with the nation's history and tradition of regulation. And now they say this touches on what is now the second step of Bruen rather than the first step. Suffice it to say that the weapons at issue in this case are bearable arms that under Bruen's first step are covered by the plain text of the Second Amendment. The court then proceeds to the second step in the analysis. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And hold on here. Yes. Defense Diaries. Hey, Bob. Yes, did someone mention the Bears? The Bears. Yes, hello. Hi, Bob. Guys, Bob and Ali Mata over at the Defense Diaries podcast. They've been covering everything like Richard Allen, Karen Reed, and I think they're on Robert. They've been on the Tellis trial lately, among other things, guys. But if you want to see them, they are two career defense attorneys out of Chicago, Illinois, as my people call it. They are over there, guys. They're great people. Very nice guys over there. So we now move on to the second part. The Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude the individual's conduct falls outside the Second Amendment's unqualified command. And they say in Heller, the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. That does not depend on service in the militia. So that's where we get the idea the Second Amendment is also the right to self-defense. And as worth noting at the outset, the court language distinguishes between possessing and carrying weapons, and that 922.0 prohibits the mere act of possessing a machine gun without regard to whether the weapon is carried or otherwise employed. Yes, and guys, that's the thing here. Simply having an illegal machine gun is the problem. Not carrying it or using it, the fact that it exists in your possession is the problem. And, the defendant argues the government cannot meet its burden. To meet its burden, the government advances only two potential historical analogs. First, the government points to English common law, which it asserts prohibited riding or going armed with dangerous or unusual weapons. Okay. Second, the government cites one of the cases from the North Carolina Supreme Court in 1824, and that's the time frame that recognized an offense to arm oneself with dangerous, unusual weapons in such a manner as will naturally cause a terror to the people. This has been cited multiple times. This was brought up during Bruen. This case about, causing a terror for the people. Well, it's because the idea you wouldn't just walking down the street, if you're pointing at everybody, merely carrying a gun was not indicia of criminal intent back in 1824. Says it, but both examples are disanalogous to what the defendant is charged with here: simple possession. And they say, as the first example, the Supreme Court addressed this history in Bruen. There, the Supreme Court observed that Blackstone's reference to English laws concerning going armed with dangerous weapons derived from the statute of Northampton, an English statute of 1328, which generally provided that Englishmen could not come before the king's justices or other of the king's ministers doing their office with force and arms, nor bring no force in a fray of the peace, nor go ride armed by night nor by day in fairs, markets, nor in the presence of the justices or other ministers, nor in no part elsewhere, upon pain to forfeit their armor to the king and their bodies to prison at the king's pleasure. So there's a lot to that got missed, huh? Good job, government. And then they say, according to the court, that notwithstanding the parties spill of its provision, the statute, at least understood during the Middle Ages, has little bearing on the Second Amendment adopted in 1791. And that is a big issue here. 1328, 1791. Yeah, that's a bit of an issue. It was focused for the most part on conduct that evinced an intent to breach the peace. In any event, was predicated on the manner in which arms were carried or displayed. And if you guys go back up here, it says, you can't come meet the government armed. That's what it's saying. You can't come before the king's justices or his ministers doing work while carrying a strap. Okay, you can't go into government buildings carrying a strap. Makes sense. To me it does. So they consider an example of the application, the conduct of Sir John Knight, who was charged of violating the statute based on allegations he did walk about the street armed with guns. And then he went to the Church of St. Michael in Bristol in the time of divine service with a gun to terrify the king's subjects. The court further observed one's conduct will come within the statute, terrifying the king's subjects, only where the crime shall appear to be malo amina and animo, with evil intent or malice, meaning you have to go running around going check this out, woo! That's going to scare people. If you're just walking down the street carrying a strap, that's not a problem. But if you come into church going, what's up, everybody? Check out my new gun. Yeah, you're going to have a problem. You're going to have a big problem. And they said by 1716, it was observed by another learned treatise that no wearing of arms within the meaning of the statute of Northampton, unless it be accompanied with such circumstances as are apt to terrify the people. So being armed was not something to scare people. It is if you have the weapon in your hands was the problem. And that was the way through the Old West. People carrying guns wasn't an issue. People holding guns is a problem. Because that means something's going down. Now, turning to the second example. And they talk about arming yourself with weapons in such a manner to cause a terror. The Supreme Court addressed this category of laws at some point in both Bruen and Rahimi, describing them both as prohibitions against going armed or affray. The latter being a term derived from a French word meaning to terrify. Without belaboring the point, the court observed these laws combine the elements of going about in a manner to terrorize the public with dangerous and unusual weapons. Nothing, 922 says nothing about the manner in which machine guns are carried or displayed. Instead, 922 criminalizes the mere possession of such weapons without regard to how the possessor uses them. If an individual purchases such a weapon and locks it away in a gun safe for 20 years without touching it, he is just as guilty as one who takes the same weapon out on the public streets and displays it in an aggressive manner. Yes, there's no distinction. If I use it to go rob a bank, okay. If I throw it in my house, it's the same crime. The statute requires no more than possession, and more importantly, it is an applied challenge. The indictment in this case alleges nothing more. More to the extent the Second Amendment would allow weapons to be prohibited solely on the basis they are dangerous, unusual, or highly unusual in society at large, as the government suggests. The government has not made that showing here. As the defendant points out, there are 740,000 legally registered machine guns in the United States today. Yes. If you go on the National Firearms Record and Transfer Registry, I think that's how it goes. Anyways, whatever. There are hundreds of thousands of machine guns that have been documented the ATF has been involved in the transferring of. 740,000 machine guns of all types. And they acknowledge it. And to be fair, the ATF has also acknowledged their records aren't complete, because prior to the digitalization of records, people have had their copies of their tax stamps, and that was the only thing that was proof. For example, I had a client who had items he had bought in the late 90s, and he had paper stamps in paper forms, and these were not digitized. And they asked about, they were checking around on things. It's like, oh yeah, I got this too. And they're like, we didn't know you had that. And he had to give them a copy of his ATF paperwork, and they took a look at it. There's stuff they don't know about out there. Machine guns have been in existence for well over a century. True. Nearly 150 years at this point. Actually, 160 years at this point. While the federal government has regulated transfer and possession of such weapons since 1934, it did not outright prohibit possession of machine guns until the Firearms Owners Prevention Act, FOPA, in 1986. Even then, the law did not prohibit the possession of all machine guns. Rather, 922-0 merely prohibited possession of machine guns that were not lawfully possessed of the date that the prohibition went into effect, May 19th, 1986. Fuck you, Hughes Amendment. Thus, even today, it is perfectly legal for a person who's been not divested of his firearms rights to acquire and possess a machine gun, so long as it was lawfully possessed. In that sense, machine guns are not unusual. The government fails to address these facts, thus fails to meet its burden. So to summarize, the government has not met its burden under Bruen or Rahimi. Indeed, the government has barely tried to meet that burden. As the Supreme Court has indicated, the Bruen analysis is not merely a suggestion. The 10th Circuit sidestepped the Bruen analysis in a challenge to the prohibition against felons possessing firearms under 18 U.S.C. 922 G1, concluding that Bruen did not abrogate the 10th Circuit's prior decision under United States v. McCain. Nevertheless, just last month, Supreme Court vacated Vincent and remanded for further consideration in light of Rahimi. And that's the case of Vincent v. Garland. So that's the issue about felons possessing weapons. So in light of Rahimi, the 10th Circuit has to relook at that. And commonly, felons were allowed to have their guns. They were allowed to be armed. They were allowed to do everything. It's just while they were in prison, they weren't allowed to have guns. The court interprets that as indicating the Supreme Court means what it says. The constitutionality of laws regarding the possession of firearms in the Second Amendment must be evaluated under the Bruen framework. Importantly, this decision says little about what the government might prove in some future case. Rather, under Bruen's framework, it is the government's burden to identify a historical analog to the restrictions challenged. The government has failed to do that. The court expresses no opinion as whether the government could, in some case, meet its burden or show a restriction that would justify 922-0. And that's the court avoiding making decisions that are not in front of it. He's saying, I'm not saying you can't do it. It's just this situation you have it. And then, oh my gosh, Judge, come on. No widows and orphans. The motion to dismiss on Second Amendment grounds is granted. The defendant's motion to dismiss on commerce grounds is moot. So there you go, chat. Suck it dry, DOJ. Suck it dry. So that is a good thing. That is a good thing. William says, how many registered ones are in Detroit? I don't know. Yes, this is something, Stabby, somebody also asked this question real quick. Did I miss it? Yes, basically under the National Firearms Act, a destructive device is anything with a bore diameter greater than 1/2 inch. So every 12 gauge shotgun in America is a destructive device. Only because the Attorney General decides, and the Attorney General has decided that most shotguns have a sporting purpose, they are not destructive devices, which would be a little awkward because, for example, like the Remington 870, there's over 10 million of those. And there are millions of single shot 12 gauge shotguns, of random double barrel shotguns you could buy for like $10 from local hardware store. All different kinds of 12 gauge shotguns out there would be a registered weapon if the government decided. It's a very true thing. It's a very true thing. So there are shotguns that fail to meet that purpose, like the USAS 12. It's a destructive device. The Street Sweeper is a destructive device. That's a shotgun with the big round drum magazines. The Striker 12 gauge is a similar gun. It's a destructive device. It doesn't take much for the government to declare it that. With the Puckle gun, I can see them declaring the Puckle gun to be, well, it's an antique because it's black powder based. But if you can make it smokeless, I could see them declaring it to be a destructive device because it's basically like you could call it a grenade launcher or something, a destructive device easily. Bob is saying back then we used to keep people in prison until their sentence was up. No, actually, we didn't. The way it worked back in the day at the time of the founding was if you committed a felony, we were going to hang you. Because there were very few crimes that were true felonies at that point. Robbery, rape, horse thieving, murder. I mean, you did those things, we would hang you. There wasn't a whole lot of jail for that. We just killed people. Bob says, how does he get his switchy back? Well, no, they can argue the switchy's contraband. But he's probably not going to get it back. Bob says the 12 gauge is common use for lawful purpose. No, the Attorney General has decided it has a sporting purpose. That determination is the only thing that protects them. I take a good says, but would buck and ball be considered destructive? No, not necessarily. Yes, cattle rustling was a similar capital offense. They'd hang you for that. Witchcraft. Well, yes, by the 1800s, there really wasn't witchcraft anymore. Yes, theoretically. Annie Land is a new member. Thank you, Annie. Defense Diary says that someone mentioned the Bears. And then Abel D says, can you money quarterback the time you and Nick went at it on stream? It was funny how Nick now looks in hindsight. Well, yeah, that changed a lot. We can look, maybe at some point we'll go down memory lane. Brimstone says, can your trust own a machine gun? Yes, trust can own any NFA items. What you can't do is register a brand new machine gun to be owned by the trust. That doesn't work. There were guys back in 2015 and 2014 who tried to do that, and the ATF accidentally did it. So there was a set of guys like out in Texas who set in their trust saying, hey, we want to build machine guns. Let us build machine guns. And the ATF went, okay, sure. Go build your machine guns. So these guys took their Anderson lowers, basically the little poverty ponies, these cheap ass AR-15 lowers, made, drilled them out and milled out the shelf and everything, and had full auto AR-15s. And then very quickly afterwards, the ATF realized what was wrong and was like, excuse me, sir, that's contraband. We need it back. They surrendered them and then sued the ATF in court. That was always ultimately the goal. And it was Hollis v. Holder. Because they were suing Eric Holder at the time. It got to the Fifth Circuit. The Fifth Circuit's like, yeah, no, we're not getting you. You're not getting your machine gun back, homie. Remember, guys, like I said, absent getting 9 Clarence Thomases on the bench, you're not getting machine guns back. I'd love to be wrong. But I really think I'm going to be right at the end of the day. That's a shame, says Indiana Court of Appeals just had a switchy case, too. I posted a quote from it in Locals. The Court of Appeals is seething. That's awesome. Yeah, the switchies are causing problems everywhere. And Tia Netta has been a member for 6 months saying, hey, y'all. Well, hello. Yes, horse thievery would get you. You would get hanged for that. Stealing a man's horse, you could kill someone. Leaving him to die out in the elements, out in the die on the frontier. Stealing horses was a capital offense. So was cattle rustling. Itchy Knee says, I'm surprised the AA-12 is still illegal. Well, that's a little bit, yeah, there really weren't too many of those made. That's part of the issue. Most of those are dealer samples anyway. William says, we don't have a Second Amendment for fucking sporting purposes. I don't disagree with you. But that is not how the Gun Control Act of 1968 is written, which talks about destructive devices and says what the Attorney General can do. So, yeah. Let's see here. You see, yeah, switchy, no cap. Brian says, to make an SKS fall out, you simply fall down a metal tab. Do not do that. You will make a runaway machine gun. That is very scary and very dangerous. And Breach says, none of those AA-12s exist anymore. That's correct. Those ones that you would have access to are gone. So that is a neat part about it. Fudbusters, yes. Matt LaRosiere, guys, friend of the channel, Fudbusters, and also Ivan the Rat. I know Ivan hasn't been on the channel before, but I consider him a friend as well. He's a very nice rat. Very good boy. Very good boy. They have a great video on the A12 if anyone's interested in watching it. Yes, it's very good. Very good. Jim says, how you doing, Jim? Says the ATF agents must have never seen the South Side of midnight. People hunt each other for sport. Yeah, well, I'm not joking. That switching, there's a reason why that switchy thing. These are kids in Chicago.
I told you my dude, I told you it's gonna get. We don't play with no regular nigga. On my butter. We do. Don't play.
Those are kids in Chicago. Those are like junior high students. So, G. Gordon says the Rekieta type. Oh, drill is born out of that environment. Yes, yes. But you know what? Those kids have bigger balls than any of us do because they're running around with machine guns all day long. And most of us would go, oh no, I don't want to. Like, if I put that on your table, you go, I don't want that. Get it out of here. Yes, I'm my brother. So, yes, Peyton is correct. Don't count on the court to end the NFA. They will not. They will not. JC says it's not balls, it's stupidity. Regardless of what it is, they are going harder in the paint than we ever will. And you just have to admit it. You have to admit it. You have to admit it. Miko's headphone says, "Chat, be proud of me. I did homework." I am proud of you. Demon's Wrath says, "I wouldn't say that. I'd say, first of all, lower your voice. And then you'd ask me, is this clean?" I'm like, well, it's about as clean as it gets. It's a 3D printed switchy, which they do make those. They don't last long, but that's the point of the switchy. Also, Shade Chaser over in Rumble says, "I just want a machine gun to stare at occasionally." It's going to be a decorative machine gun just laying there on the coffee table. Go along with the decorative cocaine. Oh. Okay. So let me see, guys, here. So, moving on, chat. Moving on. That is the good news there. Ralph's really going to show up for a fight there, and this time for real, guys. Oh, thanks, Meme. Another friend of our show, Meme Copium, Josh, was here with us last night as we were getting ready for internet history. I thought we were really going to have it. Instead of the fight at Jim's driveway, we were going to have Ethan Ralph, doing fisticuffs with Aaron Imholt. That was going to be the battle of the century, or at least the fight of the decade. And sadly, it didn't happen. So we had to go stream snipe Nick. Chop says, "Hey, Sean, have you heard about the no-knock Don the Pleb?" Yes. If you guys are not familiar, Don the Pleb from Pleb Media, if you guys have been around since like 2016, you might remember him. Very, very outspoken guy. Also, he's a member of the Future Conflict Gang. He was just arrested and served with an indictment for his involvement allegedly on January 6th, which, from having read it, it's pretty thin. It's pretty thin and kind of shitty what they've got him on. He is currently facing charges out of the District Court of the District of Columbia. And he is working on a Give, Send, Go. If you guys would wish to donate to Don, I will get that information. I will get his Give, Send, Go and all that information coming up in the future days. But just so you're aware, he did get charged. He's facing a couple of accounts. So just keep your eyes peeled for him. Don's a very good guy. Don's a very funny guy. And I think his case is a lot of bullshit. It's surprising what they're claiming he did, and they've known him for how long. And it took them 3.5 years. There's a reason why the feds are kind of dragging these out and slow playing it out for as long as they have. You got to keep it relevant. James says 3.5 years after the fact, and they're still doing this. Yes, very much so. Guys, we covered this a couple of months ago. The FBI or the DOJ said they were looking to indict and charge another 1,200 people minimum, and that was at the beginning of the year. They've got a long way to go. They've probably got at least close to 1,000 people left. They're still going to go after, and that's the ones we know of. They might be going after more. This might be going on for a long, long time. Jack Matt says no. He thinks you don't like him. Who, me? What? Oh. Never mind here. Let me see here. Do you think Trump will put an end to this January 6th shit? I hope he does, but he's got to win first. And, that's that's the first step. But yes, I'd love to see him actually do something. But remember, he got cucked and acted like an idiot the first time he was in office. Didn't do the right things. Didn't pardon Assange. Didn't pardon Snowden. Didn't do any of that. Didn't pardon the January 6th people. He could have done that before he left, but he didn't do it. So, Coke Ferry's 1,200. That many there? Oh, there are a lot more than 1,200 people there. So they're going to go after everybody they can. Kimmo says, where was I in January 6th? First of all, lower your fucking voice. Chatty Cathy. Chatty fucking Cathy right there. Okay, now moving on, guys. We have more updates. What's going on with President Trump, former President Trump, in his case out of Manhattan. He has sought a delay in the sentencing of his case, and we are going to look at that here. Yes, all the world is a stage. Yes, it is. Yes, and all are punished. And all are punished. So, former President Trump has sought a extension to or a continuance of his sentencing date that is set for September. And this is by Todd Blanche. Guys, it's Todd Blanche. This is his attorney. This is the attorney who represented Trump in New York, but it's also the attorney who got the case down in Florida dismissed. So Todd Blanche is out there doing God's work. And there is a interesting interview. Hold on here. I got to make sure I bring it up. I want to plug this interview because if you want to hear a really good lawyer, a white collar lawyer, do a lot of talking about things, this is an interview like nobody's. Where is it here? There's this guy did an interview with Todd Blanche, and it was this interview I think only like 1,000 people had actually watched, and it was really, oh god, yeah, here it is. This is the interview here. It's on the Fort of the Defense with David Marcus. It's this guy right here. And it's it's only got 3.5 thousand views, and it's 2 months old. This guy secured Donald Trump's defense attorney. Like, that's pretty fucking cool. Like, this is Todd Blanche. And if you want to hear him for 56 minutes, be very open, be very, you want to learn what makes this guy tick, and you want to hear what the inner workings of one of the guys running Trump's defense does, it's really worth it to listen to. And I think it's a shame most people have not listened to this interview and have not heard of this interview. It is really, really, really good. It is really good. I really would recommend everybody watch it. Pin it. I don't have a way to pin it. It's not mine. But I highly recommend you guys look at it. It's very good. And this guy has some interesting stuff anyway. David Marcus, just some of his other channel stuff is actually pretty good too. But yeah, if you do Todd Blanche, former Trump, if you do Todd Blanche, David Marcus, you'll get this. And actually, here, I'll put the link in chat so you guys have it. It's probably driving a popcorn fart to listen to. Well, I don't know. I really liked it. It's because it's not all about Trump. It's not all about Trump. It's actually a very good thing. It's really neat. So I would highly recommend it. It's not bad at all, guys, to get a hold of. If you can watch it, watch it. If you want to listen to it while you're driving around. Listen to it while you're driving around. All right. Anyway, let's get back to this. Geez, he only has 97 subs. I know it's a travesty. He got a hell of a get. I think they know each other, but obviously still that's a really good thing to have. All right. Anyway, they're saying, Dear Justice Merchan, the court should adjourn any sentencing in this case, and adjourning it means continue it. Though one should not be necessary because dismissal and vacator of the jury's verdicts are required based on presidential immunity until after the 2024 election. Now, he's saying, and this is where I know Pisco was very much disagreeing with me, he thinks that all this stuff is going to get tossed. I don't think so. I still don't think so. Because a bunch of this shit happened before him, but I understand he thinks it will. He says, we can agree to disagree. Well, I think it's funny. He's the one saying it's all go away, and I'm the one saying I don't think it will. You think I'd be on the other side saying, woohoo! Anyways, he says, we respectfully submit this pre-motion letter seeking that adjournment relief pursuant to the New York law, which can be deemed the motion. And once again, guys, this submitting letters is a very common thing on the East Coast. This is normally how you do things. So when you guys are looking at this and saying, well, a lot of other places they file motions, once again, guys, everywhere is different. Every state is different. Every region is different. They say, notwithstanding the court's ruling on the disputed recusal issue, the requested adjournment would prospectively mitigate the asserted conflicts and appearances of impropriety, which are also subject of an ongoing congressional inquiry, which, yes, the House Oversight Committee is looking into things. In yesterday's ruling, the court did not address the significance of the 2019 conversations with Your Honor's daughter criticizing Trump's use of Twitter, with the new fact being that existing tweets from Trump at the time of that conversation are squarely at issue in the pending presidential immunity motion. Moreover, since the most recent recusal motion, as Kamala Harris did previously, Tim Walz wrongly referred to this case in a public speech as the Democratic Party's nominee for vice president. In that same time frame, Michael Nellis, a business partner of Your Honor's daughter, Authentic Campaigns, and Authentic's founder, posted on social media about inter alia making maximum donations to the Harris campaign and using his clout with that campaign to get Walz to talk on our white dudes for Harris call last week. The sentencing is currently scheduled to occur after the commencement of early voting in the presidential election. By adjourning the sentencing until after the election, of which it is paramount importance to the entire nation, including tens of millions of people who do not share the views of Authentic, its executives and clients, where your daughter works, the court will reduce, even if not eliminate, issues regarding the integrity of any future proceedings. They point out the requested adjournment would prevent the district attorney of New York County, Alvin Bragg, in the Manhattan DA's office, from filing a sentencing submission while the court is still considering the presidential immunity motion. In an August 5th letter, Your Honor indicated the court will issue a decision on the immunity motion on September 16th, and that the existing September 18th sentencing date remains unchanged, and the parties should keep these dates in mind for purposes of submissions. However, in July, the court acknowledged the sentencing may not be necessary in light of the Trump case out of the Supreme Court. They said, we've explained in our immunity briefing why no sentencing should occur and why the case should be dismissed. He's not going to dismiss it. Justice Merchan is not going to dismiss it. Let's be real. I'm just being serious. I'm being 100% serious here. That ain't happening. Oh, somebody can't hear me? Oh, I'm not muted, right? Let's see. Let's keep going. They said, while there's a pending question before the court, the district attorney in New York should not be permitted to file a public sentencing submission that will include what the Supreme Court described as the threat of punishment in a manner that is personally and politically prejudicial to Trump and his family and harmful to the institution of the presidency as a result of the type of peculiar public opprobrium associated with these proceedings that troubled the Trump court. The request is necessary to allow Trump to adequate time to assess and pursue state and federal appellate options in response to any adverse ruling. And that's a very big point. Remember, by the 16th, he's going to make a decision, and by the 18th, we're having sentencing. You can't properly appeal in 2 days. And they say the Trump decision arose from an interlocutory appeal while the proceedings were stayed in federal court. And the Supreme Court confirmed a trial court's denial of immunity is appealable before a trial. It follows that any denial of the pending motion is immediately appealable in a similar procedural posture. And that's a very good argument. Simply put, until the district attorney in New York's presidential immunity violations are addressed fully and finally, this court may not adjudicate the matter, including at sentencing. A single business day is an unreasonably short period of time for the president to seek to vindicate these rights if he must, in order to avoid the prospect of an executive branch that cannibalizes itself in future generations. Guys, this is it's single spaced. The current schedule contemplates a type of highly expedited proceedings SCOTUS already criticized, but the district attorney has demanded. As relevant here, after wrongly denying that immunity existed for months, the DA purported to authoritatively address the scope of power and immunity doctrine inaccurately in a brief just filed 23 days after the Trump decision. They did so despite only limited federal litigation experience, with the notable and telling exception of a former high-ranking official from the Biden administration. Yep, and guys, that's the thing. There have been members from the Biden administration getting jumped onto the Attorney General's team to help them out. That is something that has been happening. Without any input from the federal government, they felt worth mentioning. The court has still not addressed our request to respond to the purported amicus brief, despite the fact the court has had an opportunity to consider arguments in that filing since July. In contrast to all of this, on August 8th, the special counsel's office notified the federal judge in D.C. they are continuing to assess Trump, including thorough consultation with other DOJ components, and have not even finalized a position on the most appropriate schedule for the parties to brief issues. Remember, we covered this, I think, the week before. Jack Smith's team said, look, Judge, we don't know where we're at. We need a lot more time to prepare. We're not ready for this. And they say the timing illustrates just how unreasonable it is to have potential for only a single day between a decision on a first impression presidential immunity issue and an unprecedented and unwarranted sentencing. And then said, finally setting aside naked election interference objectives, there's no valid countervailing reason for the court to keep the current sentencing date on the calendar. There's no basis for continuing to rush. Accordingly, we request sentencing if one is needed to be adjourned until after the election. All right. And Todd Blanche and Emil Bove, those are his guys, kicking ass out there, taking care of business. All right. Now, in response to that, Alvin Bragg went ahead and did his own response. And, they said, that's not true, basically. And hold on one second, chat. All right, we're back. Sorry. Now, going through this real quick, this is from the District Attorney, County of New York. That is Manhattan, chat. Remember, each borough of New York is its separate county. So Brooklyn has a county, Queens has a county, Staten Island is a county, Bronx is a county as well. So all 5 boroughs have their own counties. So it's Alvin Bragg's District Attorney. And they say that their letter addresses the letter requesting an adjournment. The people deferred to the court on the appropriateness of the post-trial schedule. So they're deferring to the court. And they point out that for the first time is intent to seek interlocutory state or federal appellate review before he's sentenced of any adverse ruling on his motion. It is correct that the denial of immunity from prosecution is immediately appealable. But here, in contrast to the defendant's criminal case in D.C., the question of immunity from prosecution is not presented. The only question before the court is whether a small subset of trial evidence was improperly admitted in light of a brand new evidentiary rule that derives from the official acts immunity. Yes, because remember, guys, all this stuff happened before Trump was even elected. There were things that happened after 2016 But most of it happened in 2016 and before he won the election. The Supreme Court's decision did not consider what a trial court's ruling on that question is immediately appealable, and there are strong reasons why it should not be. Nonetheless, given the newly stated position, we defer to the court on whether an adjournment is warranted, which is interesting. I'm surprised they aren't saying no. But I guess it makes them look less like assholes. Now, the reason why they don't care ultimately is that the evidence that is affected by the Supreme Court's ruling is only a sliver of the mountains of testimony and documentary proof the jury considered in finding guilty of all 34 felony charges beyond a reasonable doubt. So very likely, I think they're arguing, look, even if the juries, or even if you were to dismiss some of it, not all of it goes away. So, okay, instead of 34 felonies, it's going to be 23 felonies, whatever. We don't care. Take your time. We'll let the court make its decision. So that is what they're looking at here. Say none of the defendant's remaining arguments merit any consideration. And they say first, although couched as a scheduling request, the defendant re-raises for the fourth time a recusal grievance based on false claims of a potential conflict that have been rejected over and over by this court. Yeah, except your daughter is a major Democrat fundraiser. Yeah, this is a big problem. The first department in the advisory committee, so courts and their advisory groups have said he hasn't done anything wrong, which I still think he has. The defendant's ostensibly new argument about the court's family member's co-worker tweets is bizarre. It has nothing to do with the post-trial schedule. It's a stretch, but you know what? They're working with what they got. The defendant's concern about a public sentencing submission from the people is also misplaced. And your pre-sentence memorandum would be sealed. The only way a memorandum would become public is if the court orders otherwise or the defendant unlawfully discloses it. And they say, finally, the defendant's apparent insinuation the state's prosecutors are incapable of applying federal constitutional law is fundamentally flawed. Well, no, you guys don't really apply the law very well, period. The people in this court protect and apply federal constitutional rights every day. Not very well. Let's be real. Let's be real. They're not very good at it. Based on the foregoing, the people respectfully defer to the court on the appropriate post-trial schedule. Matthew Colangelo. And yes, it's funny. They talk about the guy who came from the Biden administration. And look, there he is. It's almost like it works that way. Yes, she was yelling at Clyde. Clyde was outside barking like an asshole. We don't want him keeping the neighbors up. So, no, that was not me, guys. That was Clyde. So, did I see at the DNC where someone would come in and place maggots at the tables? The FBI is investigating. That's funny. Oof. Extra voters are coming in. I'm just... Oh. Also, has the surprise guest at the DNC showed up yet? I just wondered who it was. Did they announce it yet? Because I was kind of curious. Did they, was it? Oh, there's so many ways that can be so funny. Let's see, because it's already 11. What do you say, Louis Farrakhan? Ah, that's awesome. Yes, Alec Baldwin comes out. I need to get a real dog. What's wrong with my dog? I was just saying, what's wrong with that? Why do you guys not like Clyde? Clyde is a good boy. Clyde is a very good dog. Yes, Clyde can do no wrong. Who said that? Who said Clyde could do no wrong? He's the best dog ever. All right. So we are through that, and we are moving on to an interesting thing here. This one is a judge behaving badly. And this is the judge. He's been removed from the bench for training after having a teen handcuffed during a field trip. And that's the thing. This isn't a kid who was in trouble for doing something wrong. She wasn't there because she was a juvenile delinquent. She was there on a field trip and she got handcuffed. Oof. Yeah. So he had a 15-year-old girl handcuffed and she fell asleep in his courtroom. Yes, that is you heard that correctly, chat. So, and she fell asleep in the courtroom during a field trip. And he also threatened to have a 16-year-old placed in handcuffs because he was not happy with her behavior in his courtroom. And the judge noticed the girl was falling asleep while she was sitting in the gallery. And he says, "You fall asleep in my courtroom one more time, I'm going to put you in the back." Seriously, it's a field trip. It's not court, Judge. It's not court. You know, this is not court. This is not court here, man. This is... Yeah. And he said, "I wanted to feel very real to her, even though there's probably no real chance of me putting her in jail. That was my own version of scared straight." It's like, no, you're not supposed to abuse your power like that. The girl was traumatized by the deal. Like, I doubt she was like really traumatized, but yes, I'm sure she was upset. So the other judges are like, "Nope, he ain't with us. He ain't with us." The judge has not reached out to publicly apologize, but says he reached out to the girl's family to offer to be a mentor to her in the future. Yes. "You know, even though I threw your ass in the slammer, I want to mentor you." It's like, what do you think? Can we be friends? Can we be friends? Like, how does that work? How does that work? Oh my gosh. Now there is a news story about it because the family has sued the judge, and I think he will lose. I don't think he's entitled to judicial immunity.
It's been pretty devastating.
This morning, the family of a 15-year-old girl in Michigan has filed a lawsuit against the Detroit judge, accusing him of humiliation, false arrest, and unlawful detention after he targeted the teen during a courtroom field trip.
One thing you'll learn about my courtroom is that I am not a toy. I'm not to be played with.
Judge Kenneth King first berated Eva Goodman for falling asleep, then had her handcuffed, ordered her to change into a jail uniform, and threatened to put her in a juvenile detention center.
I'm going to go to sleep tonight while you're sitting in the juvenile detention facility.
Eva's mother...
Oh God, Judge. You made her wear a jumpsuit? Ooh. Oh Lord. Oh Lord. He streams daily. Is it up still? Because I'd love to look for that. Let's look for... Is it available? Hold on here. Let's take a look. I just noticed he's got a thing there. Judge Kenneth King. Oh, it might be available, chat. They can't take it down. That would actually be like probably violating records rules. So let me see here. What day would this be? Streamed 8 hours ago, 3 days ago. Streamed, yeah, would it have been 3 days ago? Let's see here. During a field trip this week. August 5th. It was August 15th, so it was a week ago. All right, let me see here. No, this ain't it. Hold on, chat. Let's look. Let's look together. Uploads. Oh no, let's see here. All of them. Well, it looks like some of them are gone. Even made her change clothes. Yeah, was she strip searched? I'm sure she got forcibly searched. A job well done says, yes, Nick Rekieta told me I could provide evidence. Yes. That's not what, no. Do not play with evidence. That is a very stupid thing to do. Let me see here. Judge 36 District. Is there the actual, is this it? 3 days ago. No. 5 days ago. No. Yeah, I can't see it, guys. It's probably deleted. Well, that's a records issue, I think, ultimately. So take a look at his tie and then match it to the thumbnail. Does he have a clip channel? I don't know. Anyway, OSG says they have been deleted. Oh, that's bullshit. He should be held responsible for that because it shouldn't be done that way. Anyways, let's get back to this. Let's get back to the news story on this. So he put her in a jumpsuit.
Tonight, while you're sitting in the juvenile detention facility.
Eva's mother says her daughter was likely tired because their family does not have a permanent home.
Eva doesn't want to come outside. She doesn't want to be involved.
Now, I don't. This attorney right here is acting all serious, and he's just like, "I'm making a boat payment. I'm buying a boat. An old squishy Gardner's Court Watch. Oh, thanks for being here. I've actually I've watched your channel before. Found clips on there before. They're hilarious. He's already down. That sucks. It's gone. That's gone. Oh, we need to. Oh, screen share. Sorry, guys. Sorry. But look at the attorney for this lady. He's all serious, but he's like, I'm getting a boat out of this. He's like, do. He's like, I'm gonna have a yacht. I'm gonna have fun. Woo. That's all he's thinking about.
With no one else but family relatives, it's hard for her to sleep at night.
So that was my own version of Scared Straight.
After defending his actions in an interview last week, King was removed from the bench until he completes training, and Wayne State University dropped him as a part-time faculty member. King's attorney declined to comment on the lawsuit, saying King only wants the best outcome.
Yeah, it's a very much a lawsuit because it's like, lol, you're such a moron.
For this young person and all young people.
Well, what's the best outcome for her? What's the best outcome? Well, I know what the best outcome's going to be. It's going to be this. Shing, shing. That's going to be the best outcome. A lot of money going into her bank account from yours. That's going to be the best outcome here. So, what was he thinking? Black robe syndrome is a real thing. There are a lot of judges who think they're smart and can do whatever the hell they want. But yes, he is going to lose judicial immunity here, I think. And even if he doesn't, God, the city's going to write him a check. So good for him. Good for her. Yes, I'm John Madden. Oh no. It's not Uncle Phil. Come on, guys. He is not Uncle Phil. That's mean. That's mean to Uncle Phil. You guys are horrible. All right, guys. We are moving on from there to another place where there's a judicial emergency. And that is, here, we're going to just. All right. Trying to cancel out some crap so I don't run over it. Cobb County, Georgia, outside of Atlanta. There is a judicial emergency. And if J-Rock's out there, I know you're talking about this and what's happening. The court has actually ordered a judicial emergency and issued one. And it's because it's actually very interesting. There's a judicial emergency that basically the court has been crippled through the clerk of court not being able to do their job. So there's a judicial emergency within the Cobb County Superior Courts. And because of this, they were using a conversion of different electronic case management software, and there were separate vendors involved. And they didn't integrate the e-filing system properly. So by June, the court was notified. They notified the local bar association that filings were taking much longer than usual to show up, and that court suggested attorneys send stamp filed courtesy copies of filings to their judges, and the opposing party, when appropriate, or contact the judge's office directly. Now, they're telling them, hey guys, we can't do our job right. So, whoops the doodle. J-Rock says, I was in trial. I don't know about this. Well, you're learning about it now, J-Rock. Hopefully your trial went well, man. I know you were busy, so I left you alone, but hope it went well. So this isn't a Georgia corruption thing. I think this is just a technology issue. Since the conversion, the court's business has been impacted the following ways. The list is not exhaustive of all issues, but it represents them. So court officials, including judges, staff attorneys, judicial assistants, retained and appointed attorneys, and others. So basically, this little thing right here, this little line, basically means everyone. It's everybody. Everybody's having a problem. They can't view many documents filed both before and after the conversion. For example, law enforcement has been able to locate protective orders and bench warrants within the system, and therefore cannot enforce orders upon the violators. So there are people who have warrants, they can't get warrants. There's protection orders that don't exist right now. That's not good. Uh-oh. Uh-oh. This conversion was undertaken without consulting the judicial stakeholders. Oh, I love that corporate speak. You got to have stakeholders and plank owners involved. At least partially resulting in disruption and a loss of integrity with case numbering, internal filing practices, and many other critical court functions. Notices have been distributed by the clerk's offices because the clerks have to give notice of when cases are going, have either not been sent to have been sent to incorrect addresses, or included inaccurate information regarding the time and location of court hearings. Oh, that's bad. So it's not even they're going to the right place, but you'll get it and it'll have wrong information on there. Calendars published by the clerk's office have not been timely published so that the public, litigants, and their attorneys are unaware of courthouse business. Schedules have been so grossly erroneous that neither judges nor litigants nor their attorneys understand what cases have been scheduled and for what date and time. Oof, that's so bad. Filed documents have been marked with multiple erroneous filing dates, creating confusion among court officials. And that's a big deal, guys, because when you go back to these court documents, this stuff here is very important. We'll use this as an example, this motion in the Kansas thing. Like this thing right here, guys, that is critical. I mean, there might be times where you're trying to get, if you have a file stamp copy of something, you submitted an appeal, which are time sensitive, and they have a wrong date and a time on there. Like, how do you know that? Like, because if you get that submitted, the court might say, hey, we looked at this. Oh, you filed it a day late. Appeal denied, dismissed. But you appealed on the right time and the right day. I mean, this is a big problem. It's hilarious because I'm not there, but this is a horrifying problem. Litigants and the attorneys have been unable to verify deadlines, which that's important. Making the court sets a deadline. Okay, well, you have the right to check, which are determined by the date and time documents are filed. Yes, I have 28 days to respond from a lawsuit that gets filed. But when was it actually filed? We don't know. So when the hell do I do it? And they've been able to verify or not been made aware of when to attend court. That's a big problem. People have not been able to access their cases and filings made on the clerk's office. As part of the conversion, the clerk's office has ceased allowing defendants and their attorneys the same level of access to case files as it does the district attorney's office. This is a big problem. That's a big problem here, chat. Oh, fuck defense attorneys and fuck them. We're not gonna do anything about that. Fuck that. Fuck that. And it gets even worse, though. As part of the conversion, the clerk's office began charging indigent criminal defendants who were certified as indigent, meaning they're poor. They can't afford it. They're entitled to court-appointed counsel. Fees to copy filed documents. They shouldn't be getting charged a goddamn thing. That's bullshit. That the clerk's office has a high number of vacancies. The clerk's office has turned away attorneys, litigants, court reporters, and others from its front counter, refusing to accept documents presented for filing. Think about that. You show up for court. You show up for court. You show up for court. I'm an attorney. I tell you over the phone, hey, man, I'm going to file your case today. Or, hey, I'm going to get that motion in. And I walk into the courthouse. And and to be fair, there are places you cannot do electronic filing. There are some places that still resort to the old school ways of either mail it in or you come in person and slap it on the counter. There are some places like that still. A lot of places will let you do fax filing or e-filing, but it's not guaranteed. Some places let you email file, which there's one court that does that, and oh my God, it's amazing. So amazing. But think about that. Your attorney, and even you as a human being, regular person, a pro se party, you show up and you bring in a document for a pro se case. Sorry, we can't accept your filing. Why? Because we're not accepting filings today. Not that you're like, oh, we're going to lunch or we're closed. No, just fuck you, we're not doing it today. Like, how does that work? Copium says, what about refiling? And J-Rock says, this is fucked up. Appeal dates missed, response dates missed. Yeah, a lot of problems. And J-Rock says, because he practices down in Hotlanta, he says, we have mandatory civil e-filing there, meaning all civil cases have to be electronically filed. Well, how the fuck do you do that if your case is falling apart? This is bad. This is really bad, chat. Yes. Diversity is our strength. Not in court filings. Not in court filings. So they point out the clerk's office has lost original documents, including original indictments and accusations. Case files have appeared in courtrooms with no original indictment or accusation, or with an indictment or an accusation without a stamp date filed. Meaning, has that indictment actually been filed properly? What other original documents have they lost? Have they lost affidavits? Have they lost complaints? Have they lost exhibits that have been put into files? Missing or undated charging documents preclude judicial termination of statutes of limitation. They do. Habeas corpus deadlines. And it jeopardizes the integrity of pre-trial and post-conviction work. The clerk's office has marked criminal case files as closed, preventing staff from electronically accessing them. That one happens all the fucking time. Clerk's offices fuck that shit up everywhere. That's an oopsie poopsie. I can live with. That happens enough. That's frustrating enough. On several occasions, defendants in criminal cases have called to verify a court date. We're told no date had been scheduled, even though a date had been set. This led to several defendants nearly missing a court appearance and barely avoiding the issuance of a bench warrant. I mean, think about that. You show up. You call them. You do the thing you're supposed to do. Do I have a court date today? And they're like, no. What? You have to believe them. You have to believe them. This is... Yes, Fannie Willis in charge of this, yes. This is entirely a disaster. God. On July 11th, the clerk informed the judge e-filing would be unavailable from 5 p.m. until July 15th. This period was extended later to July 16th. During this time, all filing had to be made in person at the clerk's office. The court informed the local bar of this, and that's not the worst thing in the world. Okay, that was going to happen. On July 30th, the clerk informed the judge the processing of certain filings would be delayed due to the conversion. Specifically, depending on when a document was filed, it might not be visible for between 25 and 35 days. That's not acceptable. The clerk's office also advised that closed cases would not appear electronically, and litigants desiring to e-file into a closed case were told to contact the clerk's office for manual intervention. Okay, well, I mean, that's not too bad. But the 25 to 35 days is not acceptable. But anyway, the judge says paragraphs 1 through 4 constitute a serious emergency. The nature is that the clerk of court's conversion has so disrupted the functioning, it's infringed upon the normal functioning of the judicial system and the ability of people to avail themselves of it. The chief judge also believes this has raised serious due process and other constitutional concerns, and it has. Rights to speedy trial, just in general, whether or not your charging documents are valid. But here's what they get to do. They get to declare a judicial emergency. The chief judge is authorized to suspend, toll, or extend, or otherwise grant relief from deadlines or other time schedules or filing requirements imposed by other applicable statutes, rules, regulations, or court orders, whether it's civil, criminal, or administrative matters within the court. So there you go. So the filing items shall be granted relief for 30 days following the date of this order. A statute of limitations. Yes, because the court fucked up, they're going to fuck you as a defendant over. They're saying, look, bro, sorry. I'm so sorry, but I'm going to give the state 30 more days to shove it up your ass. But it's not your fault. You didn't do anything wrong. They don't care. They don't care. They don't care. They don't care. The time in which to file a writ of habeas corpus, which is good. The time within which discovery or any aspect thereof is to be completed. Okay, that's fair. The time with which to serve a party. Okay. Motions for a new trial. Answers in civil cases. The time within which to seek appeal, the right to appeal any order. Okay. Ruling or the determination. And such are the legal proceedings as determined necessary. So they point out that to do this, the clerk of court is ordered to give the public free and open access to the system in the same manner as it was before it started the conversion. Which I don't know if it can really do. I think it's a little too late for that. Bruen says Rekieta vindicated. Yes, he's like, look at Georgia, something happened. I'm a winner. I'm a wiener. Alrighty. So there you go, chat. That is just an example of the court system falling apart. The court system falling apart. And then let me see here. Where are we to? All right, we got two more things. Cain Velasquez. You guys don't know who Cain Velasquez is. Why is this? He has pled no contest to shooting a man. So there you go. You guys remember Cain Velasquez? He was accused of shooting at a gentleman who he believed had diddled his child. The problem was he shot at the wrong guy in the car and wounded his wounded that guy's family members. So he ended up giving up his jury trial. He pled no contest to attempted murder and 8 additional other charges. The reason why he did this is allowing him to avoid a life sentence in prison. So what happened? Well, this goes back to he tried to kill Harry Goulardi because one of his kids had been alleged to have been molested by him at the daycare where this guy worked. So he did grab a gun and he chased down Goulardi with his mom and his dad in the car. And he drove to 100 miles an hour as he chased them down the 101. And then once there, he ran them off the road and shot the driver in the arm as they fled past. Which, great. He shot near a charter school, which makes it even better. So they searched his phone, chat. They searched his phone here. They searched his phone. And once again, your tattle machine, they searched. And what did he type in? What did he type in, chat? What did he type in? Sexual assault cases where the victim's family fights back. And sexual assault cases where the victim's family retaliates. Oh. So, as part of the plea deal, he pled no contest to felony murder, to attempted murder, felony assault charges, and gun-related charges. Why the fuck would he look that up? I know. Why not just if you're going to do it, fucking do it. Yes. He typed hose long to die of bolt. Yes. Yes. God bless Gary Plauché. Yes, but here's the thing. That guy got caught. And he had already been caught with Gary Plauché's son and then escaped again. Harry Goulardi, I don't think has actually even pled yet. He's still... his cases are still pending. So, it hasn't actually been set yet. So, we will see what happens there. And, yeah, it's sad because, Cain Velasquez is he had a pretty good history with the UFC. And he's probably going to fucking prison at the end of the day, chat. Is he going to be able to blame CTE? Probably a little bit. I mean, he shot the wrong guy is the problem. That's the issue here, Chad. If you're going to do vigilante justice, at least hit the right guy. He hit the wrong people in the car. And that makes it even worse. So no, he's not going to be able to plead insanity or mental defect because he entered a plea of no contest. So how much time is he looking at? I think he's looking at probably at least 20 some years minimum. But I mean, he's probably going to get, probably 5 to 10 years, I bet. I don't think it's going to turn into something where he's just going to walk away like it never even happened. He's 42. He remains out of custody. He will be sentenced later. It was very interesting because during his preliminary hearing, the accused child molester, because the victim was testifying, he refused to testify and invoked his Fifth Amendment rights, which sounds like he probably did diddle little kids. Probably sounds like he diddled little kids. But yes, Cain Velasquez is looking at a lot of prison time, so we'll see what happens. And if you guys don't remember, Cain Velasquez is one of the kind of OGs in the UFC, the Ultimate Fighting Championship. He is a two-time champion of the heavyweight division. He's been around forever. He has been around forever. So he's an old man in fighting. He's 42. And we'll see. We'll see what happens there. Let's see. How much time is he looking at here? Yeah, I mean, he's looking at a ton of time, chat. He's looking at tons of time. He had cardio and no power. Yeah, but that was old enough. Mofolk says he's an old man at 42. Well, for him, yes. For him, yes. For the UFC, yes, it's old man. Yes, ScudX, yes, he made Brock Lesnar quit MMA, basically, yes. Cain Velasquez was a destroyer. He was yes. Why, Gary? Why? Yes, if you're gonna be a vigilante, don't. Or if you're gonna be a vigilante, fucking get the right person at the very least. Or nobody's gonna feel bad for you. Don't just fucking hit the wrong people. And don't get into the shootout next to a fucking school. That is not gonna help you either. That is not going to help you either. Don't do that either, chat. All right. And the last thing we have is just very interesting. It's just kind of it's a good way to wrap up because it's things wrapping themselves up. Now, the sentencing judge is going to be a huge MMA fan. He'll get 18 months. That would be hilarious if that happened. That will really be hilarious if that happens. All right, so the next thing is Sarah Boone. We have an update to some things, and this is just like I said, guys, we're wrapping up the show, and I thought this was a great way. We're wrapping things up. And in Sarah's case, her prior attorneys are trying to wrap things up. So here we have, and this just so you understand like how much this all works out. This is Patricia Cashman's motion for attorney's fees. Because remember, Sarah has had court-appointed counsel. So she is billing on this, and the case has reached a billable point because she's done. The Justice Administrative Commission's response to the billing was to object to the flat fee amount of $15,000 for attorney's fees and the $1,800 for reimbursable costs expended by this attorney. So she's requesting a hearing, and she's saying, I've done more than $15,000. I did $15,000 worth of work, and I spent over $1,800 in cost, and you need to reimburse me. And the JAC is saying, nope, we're not paying for it. And she has timesheets for this, but she said over a 4-month period, she spent well over 100 hours on the case and was evidenced by her certificate of time. Over 20 of those hours were spent with Sarah. And she says Sarah was charged with second-degree murder. There was a vast amount of media attention. There was a video of the incident that went viral. Counsel made preparing this case a priority, as it had been pending since 2020. And then she says, the final disposition on my part of it was an order that Sarah Boone waived her right to counsel. There was a bunch of discovery to review. Multiple CDs, DVDs, paper discovery, over 400 pages of reports and statements, 2 baker's boxes of files obtained from the previous attorneys, and background information on the relationship between Sarah and Jorge, her boyfriend. The state listed 23 witnesses, 2 of whom were deposed by this counsel, and 7 of whom were deposed by previous counsel. Wow, so her counsel, like Sarah's attorneys have been busy. They've deposed 9 people, 9 depositions. Man, her fucking attorneys were putting in work. They were working hard. So, she also reviewed the media accounts that jurors may have seen, because she had to. Some of us got covered in here. Court TV, News Nation, Fox, Local News, Orlando Sentinel. Lawyer, you know, shout out Peter Tragos. You made it big, brother. Legal Bites. Okay, congrats. And then Bruce Rivers, the criminal lawyer. did multiple stories on their channels. Many of the previously held court proceedings were televised, and the letters written by the defendant were published and analyzed. The defendant wrote a 58-page letter to the court and had previously written multiple long letters. Counsel needed to review to determine the impact on the case and develop a strategy for jury selection. Over 20 hours of jail conferences. She submitted a jail voucher, and she is entitled to get paid. So she's going to say what she can do. And she's saying that she did all this work, and she won $16,800. And here's they object, and they'll do her attorneys, they'll do her fees, but they are not giving her $15,000. And they say, you were appointed on February 9th. The legislature established flat fees of $15,000 for representation in non-capital murder cases. They're pointing out the aggregate amounts billed for the attorney's fees amongst all attorneys appointed to represent have exceeded the flat fee established in the General Appropriations Act. So they're saying that they're all the attorneys all together have to piece apart that $15,000. Where the court appoints more than one private attorney, the total compensation may not exceed the flat fee. Absent a hearing. Well, you were appointed in this case, but not represent the client through the entire course of the case. Thus, the court appointed more than one private attorney to represent this client. The court must apportion the flat fee among all appointed counsel who worked on the case. In this matter, you were the fourth of four attorneys. So we'll see here. Here are the people. Because the court must apportion the flat fee, you will need to coordinate the hearing date and time with all the attorneys listed below. So here's what people are asking for. Frank Bakowitz is billed $15,000. And he was the guy that kind of fucked around for a while. Winston Hobson was around for a couple of months. He's asking for $15,000. Patricia Cashman billed $15,000. And she was on it for like 4 months. In order to discharge in counsel, find the defendant's forfeit and waived. And then they point out that the defendant is now pro se. And they say if the attorneys are agreeable to a division of the flat fee, the attorneys may execute a settlement agreement. Fuck that. Fuck that. Holy shit. That would be fucking awful. Having to come in and fight for scraps. Oh no. Fuck that. Ain't no motherfucking way. Ain't no fucking way that happening, Chief. Ain't no way. Whoo! Ain't no way that happening. Fuck that noise. God damn. Yeah, fuck that. Fuck that. So compensation, the excess. The chief judge or designee must hold a hearing on whether to exceed the flat fee. So the judge can order payment. The judge can order payment, but he is allowed to do what he wants. So so they sent in her status thing here, and this is actually so on the 9th, the first day she got it. She was at the status hearing. She conferred with the client, conferred with the prosecutor, emailed previous attorneys. This is billing by the 10th of an hour, so every 6 minutes. 6 minutes. This is the standard for billing in the legal industry. So she drafted an email with discovery. She sent a letter to the jail. She emailed with stuff at the jail. She has a lot of fucking work to do. And she broke it down. She broke down, and this is actually very detailed. Very, very detailed. But she, reviewing the media on the internet the jurors will have been exposed to, like Legal Bites. Let me see. God, our name's got to pop up here. Court TV. The Parkland judge is interviewed. She weighed in. That spackle factory of a person. So there's a bunch of reviewing depositions 40, 50-page depositions in 4 hours. Just visiting things. Going to jail to confer with the client for 1.5 hours. She had to prepare before she went over there, so she had to read for like 45 minutes. Listen to the 911 call. Like, you have to spend time re-going through a bunch of shit here. Watching 8 body-worn cameras for 2 hours. I mean, there's a lot of things she has to go through. Researching battered woman syndrome, what she could do. That's it, it's adding up. It's adding up. It's adding up. Let's see if there's more. KYL. Or maybe that means lawyer, I don't know. Yeah, we're not in here, chat. But yeah, total hours 118. And what's 118 divided by 15,000? So 15,000 divided by 118. That's $120, $127 an hour, chat. $127. That's all she's asking for. $127 per hour. That's all she's gonna get out of this at the end of the day. And easily, I can see her busting her ass like this. It's a lot of work to get this done. A lot of work to do this. And the judge is like, we gotta go. It's time to go. Well, she made it a priority. That was part of her being brought on, was to make this happen. Make it go, make it go, make it go. Well, she did that. She did that. So that's what's going to happen there. Damn it, I was just tapping that out. Sean, use a calculator. And then there's another attorney, Frank Bankowitz. And he shows up. And we already talked about it real quick, chat, but he's standing in the background saying, like, oh, yes, hello. You may remember me as the attorney that doesn't appear to do a whole lot. This undersigned counsel was attorney 7 on the case. Yes, he was attorney 7. He worked on the case for over a year and had spent approximately 175 hours, including 45 with the defendant. He's asking for $15,000. And he wants just the straight $15,000. Because that's the cap. And he's worked over that limit so far. And that's the thing when you are doing court appointed stuff, it's very easily, especially in a bigger case, to max it out very quickly. And then you have to petition for extraordinary fees. So, yeah, here is Frank Brankowitz asking for $15,000. He worked for 175 hours. You're just like, bro, I don't know about that. He also didn't include all the shit that Cashman did. So I don't know what that's going to do for him. Do I think Nick's lawyer is billing him for watching streams? He might if he asked him to. Then yeah, I'm sure his attorney said he was going to do it. So yes, is getting compensated when you are representing indigent clients is sometimes not an easy, straightforward task. Spending time with Sarah should be billable as double pay and double time and hazard pay. Yes. Yes, it is. Bob says the partners I used to work for billed around $1,000 per hour. Well, yeah, that's a little bit different. Maddie B says when I ran my shop, I charged $115 an hour. Yeah, that's the thing. It's not, in here. I mean, like here in Ohio, the most any county will let you bill at is $75 an hour, and that's a handful of counties. Not every county does it. A lot of counties do $50 out of court per hour and $60 in court per hour. So, just saying. I am just saying. Show screen. Yes, I did show screen. So, all right, chat. We are. If I was the judge in Boone, would I be doing things similar? I think this judge does too much of not wanting to answer or deal with her. But there's a lot to talk about with him. But overall, no, I would not be doing it the way he's doing it. I would not. Miko says in 2024, that's absurdly low. That's the way how much the government is willing to pay attorneys to represent the indigent. Justice says, why not be a plumber at that point? I know it's understandable, but it's like if you do them all that way, well, yes, that would look really bad. But you take a couple and, you know, you have appointed cases along with retained stuff, and yeah, it's not too bad. So that is it tonight for us, chat. That is it. We are all caught up. We got through quite a bit tonight. I think we did awesome. That's a shame. Says, yikes, that's rough. Indiana statewide mandated PD rate of 90 an hour. Ooh, that would be nice. $90 an hour, almost $100 an hour. Sign me up. Be a plumber, $139 an hour, but Canadian. Well, that's the... Is it really worth it to be Canadian? I don't think so. I don't think so. Ethan Rouse lawyer is also a plumber. All right, guys. Well, thank you all for being here, guys, tonight. Thank you. So many people here, guys. If you are new, please like and subscribe. We do this every Thursday. We cover, we try to cover at least one real court filing as we're going through, and then a bunch of stories along the way. Some of them are funny. Some of them are serious. Now, I thought this was a nice little balance tonight. And yeah, we try to keep it under 2.5 hours is our goal usually. So yeah, we are there. It's time. And I want to say to everybody again, thank you to everybody on Twitch, the 4 of you that are out there. Everybody over on Rumble, looks like Doxyland and Shade Chaser are the only 2. And then everybody over in Locals. And then last but not least, everyone here on YouTube. Guys, thank you so very much. And all I can say is at this point, guys, this weekend we are going to be covering Robert Tellis. We'll be covering his when he takes the stand, because this appears to be just straight up lulls at this point as he's getting grilled by the prosecutor with insane answers to the questions. We'll be working on that. Certainly, if any more interesting matters of public information drop, we'll be covering those as well. And in the meantime, chat, I guess as always, and last but not least, just because you did it doesn't mean you're guilty. Unless you're handcuffing like 13-year-old girls because you're an idiot, then you probably are guilty. Don't do that, chat. Don't do it. Guys, I will see you over on Locals very shortly. And until then, chat, take care and enjoy your weekend, guys. Good night.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?